4. Welcome.
Thank you. Thank you, Mr. Chairman, members. On first glance, Assembly Bill 139 might seem a little bit tedious or on a subject that is not that interesting, but I can tell you with a straight face that this bill is probably one of the most important things that we can do for our middle class and working class constituents in the state of California this year. Right now, as the committee knows, if you want to transfer any asset upon your death, for just about any asset now in California, you can do it in an easy fashion. If you want to transfer your car, for example, you can fill out a form with the DMV that comes right with your car. It's part of the pink slip that says, upon my death, I want this car transferred to so-and-so. The same applies, of course, to a retirement account of any size, a multi-million-dollar bank account, a multi-million-dollar retirement account, a multi-million-dollar stock portfolio. All of these things have what's called transfer on death, payable on death, or so-called TOD trusts that attach to them that allow you to transfer this property outside of probate. There is, however, one major exception. That exception is houses. It's one of the few assets anymore that cannot be transferred outside of probate, and therefore millions, literally millions of American families have to go out there and hire an attorney and pay to create this legal fiction of a living trust. And it's usually just to pass that one asset at home. So if again, you think of the typical family, or maybe the not-so-typical family, who has a small retirement or a pension, that can be passed with a payable on death provision in the pension. If they have a bank account, the minute that they sign up for that bank account at Bank of America, Wells Fargo, they can fill out a form that says, upon my death, transfer this bank account to my children, to my spouse. That applies to their cars, to all of these things in California, but it does not apply for a piece of real estate. This bill would adopt in California what I think is becoming a trend. 25 other states have adopted this payable upon death deed provision. What is a payable upon death deed? It's a deed that you fill out with all the formalities of a traditional deed. It has to be notarized. It has to be signed in the presence of a witness. It has to be recorded. And the deed simply says, when I die, I want my house to go to this person or that person. What are the safeguards in place for this? Well, there are many. First of all, it has all the safeguards of a traditional deed, all the safeguards of a quitclaim deed or any of the other deeds that people use to transfer property. Secondly, the recorders in California, and this is a point that should not be missed, the recorders in California send out these pieces of mail when one of these deeds has been recorded. And it just says a document has been recorded on your property. It notifies the homeowner that if they did not do it, to call the Department of Consumer Affairs or the registrar. And there's 2 mailings that go out in the average county. This process is very easy. I recently did it myself in the state of Arizona. It's an easy, safe process. It's something that I think we should bring to California. It's just illogical, and it's unfair, and it's an unfair burden on middle class and working class families to have to be able to they can pass their entire estate, but for that one last asset, they have to pay thousands of dollars, if not tens of thousands of dollars, to an attorney to get a trust. So I respectfully ask for your aye vote.
Thank you. Your witnesses in support.
Good morning, Mr. Chair. Mr. Chair, members, I'm Brian Hebert. I'm the Executive Director of the Law Revision Commission. I'm here today just to help answer any questions you might have.
Thank you. Other witnesses in support.
Larry Doyle on behalf of the Conference of California Bar Associations. The conference has long been a supporter of this concept. We did so when Assemblymember Wagner had his last bill before the committee. Since that time, the number of states that have adopted revocable transfer on trust death deeds has doubled. There is still no evidence that can be found that this is a problematic situation or that it opens up any issues of fraud. As a matter of fact, just as an attorney who has practiced trust and estate law, if I were looking to try to create a fraudulent situation, I would definitely go with trust rather than this, because it would be far easier to take advantage of a vulnerable senior under those circumstances. This is a growing trend. It's a very important, as Assemblymember Gatto has expressed, and I strongly urge the committee's support for the bill.
Thank you. Next witness.
Gerald Richards, and I'm here representing the California Senior Legislature. We strongly support this bill for the reasons that Mr. Doyle just stated. I myself worked for a number of years as a volunteer attorney with senior legal services in Contra Costa County, and I encountered a large number of seniors whose only asset was the home, and they were quite unable and in many cases reluctant to consult an attorney about anything. And none of them were ever able to understand why you can't just fill out a beneficiary statement and transfer your house.
Thank you.
Thank you. Any other witnesses in support?
Yes, Mr. Chairman, members, David Wolf here with the Howard Jarvis Taxpayers Association. We too have been long supporters of this proposal and do believe it does simplify the transfer of real property, which is important, especially for elderly residents. We think this is a great bill and would ask for your support.
Thank you. Any other witnesses in support? All right, witnesses in opposition. Come forward, please. Morning.
Good morning, Mr. Chair, committee members. My name is Craig Page. I'm with the California Land Title Association. We do show as formal opposition on the bill, but are working with the author of the bill to work out the concerns that the industry has about fraud, and we'll be working with, hopefully, with some amendments on the bill. And at this point, we will be neutral in working with the author.
Thank you.
Good morning, Mr. Chair and members. Lexi Howard with the California Escrow Association, echoing the sentiments of Craig Page. We have some concerns with regard to some of the technical matters in the bill, and we're working with that. Would also like to thank your committee staff for their fine analysis and work on this bill.
Thank you. Any other opposition or neutral?
Thank you, guys.
Thanks. All right, seeing none, I'll bring it back to the committee. Committee questions. Mr. Gallagher?
First of all, I want to thank the member for bringing forward this legislation. I do some estate planning in my law practice, and I've always thought it was kind of frustrating at times when you had property that either wasn't transferred to the trust prior to death, or just people that never did do that estate planning beforehand. But now you have to go through this more complex, either a probate. Sure. Or there is a procedure, small estates procedure, but it's only, I think, for property up to $150,000. So I commend you on bringing this forward. I think this could be a good way to allow for those transfers. On the issue that's raised by the Land and Title Association, could one way of dealing with that is just say that the last recorded trust deed would prevail over any other ones recorded previously? I mean, have there been any ideas on how to deal with that situation? If you had multiple recorded on one property, there could be confusion over title.
Sure. Yeah, we will work with them very closely. I respect the neutrals or the opponents very much, and have a good relationship with them. We're going to work with them to work through that issue and any other potential issues. We want to, of course, keep the certainty in the title insurance process, and we also want to reduce the possibility of fraud. One of the ideas that has come up, of course, is some sort of presumption. Obviously, if somebody does this on their deathbed or something, there's already presumptions that exist for a lot of the estate planning industry. But one of the things that was pointed out, which I think was an excellent point, is arguably the estate planning instrument that is most subject to fraud is the trust. Ironically, it's the thing that most people turn to pass their real property, because as we all know, if a trust specifies that an amendment can be done by the trustor, all that person has to do is go in there. Well, all that anybody has to do is go in there and handwrite something and saying, this is a trust amendment, I give my whole property to blah, blah, blah. And that happens. I mean, that happens. I know several instances where that has happened, where there's been an allegation of fraud within a trust. So we actually think this, by being a deed, something certain, something that has to be notarized, something that has to be recorded, something that is mailed then to the actual person who allegedly recorded it, that there will be a lot of certainty in the process. But we will work with them to work through all the kinks and make sure that this process adopts the best practices that have been used in the 25 other states that use it. Thank you.
Mr. Gallagher? I'm sorry, Mr. Wagner?
Oh, just briefly, thank you for bringing this forward. I think it solves a lot of problems, obviously. I'm a fan of the bill, having tried it before. Your problem, I think, will not be in this House. It'll be in the Senate, where this bill has died a number of times. So I wish you all...
I'm knocking on some wood now, and it is St. Patrick's Day,
Wish
so I
you
need
all the luck
Mr.
in the
Gallagher,
world.
I need some luck. So thank you. Thank you.
The folks who have gone neutral, you've said you've got a great relationship with them. I mean, I know in some bills that I've worked with them, they are very accommodating and eager to work towards getting some good legislation. So I'll just add, I encourage you to work with them so that your path is smoother in the Senate. Wish you all the luck in the Senate.
Thank you.
And with that, I'll move the bill if there's not a motion.
Thank you.
So we do have a motion. Is there a second? Second. So there's a second. Mr. Mainshine?
Mr. Gatto, just a quick question. I'm in support of the bill. By doing this, would this take the value of your home out, delete it for income tax purposes towards the total, towards the total estate value?
So you're asking whether this would somehow void the $5 million estate tax?
Yeah.
I don't think there's anything anybody can do to do that.
Well, does this count as part of the value of your estate, or is it past?
Yeah.
It does.
Yeah,
Okay.
it does. Yeah. It does. I mean,
I'm supportive of the bill. It's a great bill. I was just curious.
Death and taxes.
Yeah.
I mean, can't avoid them. Yeah. But thank you.
If you could come up with a bill on the avoidance of death,
I'd run for Congress to do it. Thank you.
That'd be great. I'll co-author that one.
Thank you.
Yeah, it just removes it for probate purposes, but certainly not for tax purposes.
Well, and just to follow up, the reality is this bill, more often than not, overwhelmingly is going to apply to the lower estates anyway.
For
Folks
sure.
with those sorts of assets are going to have other vehicles in place. So.
For sure. That's true.
That's true. Other committee questions? Seeing none, Mr. Gatto, you may close.
I respectfully ask for an aye vote. Thank you.
Thank you. We do have a motion and a second. Call the roll, please.
Stone.
Aye.
Stone, aye. Wagner.
Aye.
Wagner, aye. Alejo. Aye. Alejo, aye. Chow. Chu.
Aye.
Chu, aye. Gallagher.
Aye.
Gallagher, aye. Garcia.
Aye.
Garcia, aye. Holden. Aye. Holden, aye. Mainshine.
Aye.
Mainshine, aye. O'Donnell. Aye. O'Donnell.
And that was due pass as amended to appropriations. So you're
Thank you very much.
so it's just due pass. So your bill is out. Thank you.